Acknowledgement, the Appraisal Contingency Addendum, and the Seller's Property Disclosure Statement. All of those were released on July 1, so hopefully you're seeing those in your library. And then I'm going to go over a little bit of seller disclosure law basics. If you have more specific questions, you can absolutely send them to me or the hotline afterwards, but I'm just going to touch on some very simple basics. With that, I'm going to start with the COVID-19 property access notice and just review a brief history of the COVID forms because 2020 was such a great year. Let's relive it. So the first form that we released was the COVID addendum to the agreement of sale. It was used as an emergency extension device when the world was shutting down and no one was allowed to do anything, even remotely. Business has obviously roared back to life. And even though it may not be under the same circumstances, I think it still has use. We do get calls to the hotline more than I would like because one of the parties in the transaction has COVID and is in the hospital and can't continue with the transaction. Having the COVID addendum as part of the agreement would allow that party or someone on their behalf to invoke a one-time extension of the deadlines that haven't yet passed. This doesn't mean that the parties couldn't agree to yet another rescheduling if needed, but it does allow a party to relieve some of the pressure in an emergency. Now that the numbers of cases are climbing again and the next few months may be a little uncertain, it might be a good idea to dust off that form and consider making it part of your agreement. The next forms that we released were the property access notice that first came out in May of 2020 and then was revised again in July that year and then July of this year. And this is simply meant to be a notice of the rules and a liability waiver for agents. So it was mainly a tool for you to use to protect yourself and your clients against liability for conducting in-person activities during this time. We also released a health and safety acknowledgement with the health screening questions. And these two forms were helpful when we were finally allowed to conduct business in person again, but there were restrictions on how it was done. Now that the restrictions have been lifted, using these forms makes less sense. And you see in the COVID HSA line, it says bye-bye because the release of the revised property access notice means that we have actually removed the health and safety acknowledgement from our library. So what has changed? The current property access notice combines the health and safety acknowledgement and the old property access notice into one form. And it, again, removes that old health and safety acknowledgement from the forms library. The new form instead covers all the bases and alerts the parties to what a property owner may require for access to their property rather than providing specific information. So rather than saying, these are the rules, these are the things you have to do in order to get access to a property, because again, it was the same everywhere. There were the same restrictions everywhere. Now we've reframed it to providing examples of what the property owner could set as restrictions. You'll also see that we're not asking specifically about symptoms the way that the former health and safety acknowledgement did. We're not asking anyone to divulge their symptoms, their exposure, or their vaccination status. Instead, we are just replacing it with basically a plea to be smart and courteous and just not do things in person if you're ill. So here you see it says things that may be required by the property owner. And this is just our begging you, please, please, please don't be stupid and don't conduct in-person activities if you have any of these symptoms. So some common questions that we still get on the hotline about this form. First, is the property access notice or any part of it required? No, not really. The form is not legally required, so there's no regulation, no order, no law that says this has to be completed in order to access a property. However, your brokerage or the property owner may insist on it, and that is legal, that is fine. Now that the only form left is the property access notice, which is not exchanged between the parties, it's not very likely that you'll have a seller or landlord insisting on having the form completed, but you might. And again, your broker might require you to give it to all of your potential clients. Second question is, can the sellers require vaccines? Yeah. Basically, it's the seller's house and they don't have to let people in if they don't want to. And if they want to see some evidence of vaccination status or some acknowledgement that the person coming into their property is not ill, then they are allowed to ask for that. Third question is, what about Hipaa? And this has actually become a running joke among the hotline attorneys. Because we just want to pull our hair out and scream. And I think if I hear this excuse one more time, I'm going to quit. It is no more of a Hipaa violation for me to ask you how you're doing today, or if that's a sunburn, than it is for me to ask if you've been vaccinated. I can ask you if your headache went away or why you're limping, and that is not a Hipaa violation. Asking the question is not a violation. Furthermore, you can answer. You can volunteer information about your own health, and that is also not a Hipaa violation. You can tell me you got too much sun this weekend, or that you twisted your knee dancing on a table. For the most part, Hipaa is not going to apply to any questions you ask or information you give, because an individual can answer questions about their own health, and that has nothing to do with Hipaa. B, you're not a healthcare provider. So please, for the sake of my sanity and the sake of the sanity of the hotline attorneys, stop with the Hipaa argument. So that is our new property access notice. The next form is the commercial property management agreement. And this is kind of a brand new form, but not a new concept. So we had a property management agreement for the longest time that didn't specify whether it was residential or commercial. When the landlord-tenant task force began working on forms a few years ago, we considered revisions to that form in particular that would make it specifically for residential properties. We asked and asked and asked the members if they used that for commercial, and we got no response. But of course, as soon as we took the plunge and made that form, specifically the residential property management agreement, we heard the unhappy cries of our members who said, wait, we use that for commercial properties. And rather than undo what had already been done, we created a second form. So the two forms, if you're familiar with what is now the residential property management agreement, they are relatively similar to each other. They have some similarities, and their differences are few. It's a relatively uncomplicated form because it can be a complicated process. And what I mean by that is that there is, if you look at the form, there are a lot of blank spaces and there are a lot of options. There's a lot of standard language, of course, but someone filling in the form has to know what they're doing. These forms are similar to one another, with the only distinction really being the use of the property. The commercial property form is a little more vague because of the many different ways that a commercial property can be used. But for the most part, they track each other closely. But that doesn't mean that just because you're familiar with the residential property management agreement, that you should just whip out the commercial form and dive into the world of commercial management. Property management in general is still one of the top 5 topics that generate hotline calls and questions. This really is not an area to just dabble in. So remember that property management, including commercial property management, should only be done by a broker or a supervised salesperson. And there are certain activities that the State Real Estate Commission says can only be done by a broker or a property owner. And that is independently negotiating the terms of a lease and signing a lease on behalf of the property owner. So you have to be a broker or associate broker to do those 2 activities. But again, if you want to take a look at the form, if you have more specific questions about this form, please feel free to follow up with me later. I'll be happy to answer them for you. It's just that it's so similar to the current property management agreement. There's really not anything specific for me to point to, but if you have a specific question, I'll be happy to answer it for you. The next form is the Appraisal Contingency Addendum to the Agreement of Sale. This is one that I never really expected to cause such a stir, but it really has put people in a tailspin. The current market is really what drove a change to the form. So you're all aware that the current market is absolutely wild. Competition is fierce. And that has been leading people to overbid on properties by thousands of dollars, their spare kidney and a dragon egg and whatever else they can spare. The problem is, what if the property does not appraise for that amount? So we called that gap between the appraised value and the agreed upon purchase price the appraisal gap. Buyers didn't want to include an appraisal contingency addendum with their offer because that would make it look weak. So buyer agents started writing their own language that they felt would help nonetheless protect their clients. The problem is that it really wasn't much help at all. Even our form now doesn't specifically talk about that appraisal gap because it generally wasn't the gap that was the problem. It was the buyer's options that were the problem. So the language that buyer's agents were writing was geared more towards what happens if there's a gap. And there was yet another gap in the language that was being drafted because it just wasn't completely thought through. Buyers who included that appraisal contingency addendum looked like they were giving a weak offer. And why is that? It's because they could terminate the agreement. And no seller in their right mind would want to deal with that. So what we did was change the options rather than address that actual figure in the difference in dollar amount between the appraised value and the purchase price. So question that we get is, what number should we put in paragraph 1? And this is for the new appraisal contingency addendum. As you can see, if you are familiar with the old one, paragraph 1 really hasn't changed that much. There is some additional explanation and more language rather than just the 2 checkboxes, but essentially it's the same. You're setting a minimum appraised value, and it's either the purchase price or it's a different number. If that blank in the first line of paragraph 1 is left blank, then the purchase price is the applicable price for the addendum. If the buyer only wants protection for $200,000 and there's a $250,000 purchase price, you'd want to fill in the blank with the $200,000 and cross out the words on the next line that say whichever is less in order to make that make sense. As always, make sure that you fully educate your clients on how best they would like to complete this form. The second blank in paragraph 1 is for the length of time. The default time period has stayed at 30 days as it was before, but that can be changed, of course, by completing the just putting a different number on that blank. And that is the time period for the buyer to get their appraisal completed, whether it is done by a lender or whether they're finding someone to do it themselves. It has to be done within that time period. So paragraph 1, again, relatively the same as it's always been. Paragraph 2 is what has caused the problems. The other question that we get on paragraph 2 is, does the seller have to reduce the purchase price? Option 1 here in paragraph 2 is basically the old appraisal contingency addendum. If the property doesn't appraise for a certain value, then the buyer has the option to terminate the agreement or renegotiate. So there is nothing that says the seller has to reduce the purchase price. It's not a presumption. As before, nothing requires that because it's the price that's already been agreed to in the agreement of sale. But while buyer's election of option 1 should signal to the seller that renegotiation might be the route that the buyer wants to take, the seller is under no obligation at all to reduce the purchase price. The price is the price is the price. Next question is, well, if the seller doesn't have to reduce the price, doesn't the buyer just have to pay more cash? Well, maybe. Again, the purchase price is the purchase price is the purchase price, and it's already been agreed upon. However, by electing option 2, the buyer's indicating that they're not going to terminate if the minimum appraised value is not met. And instead, they'll be making up the difference in price somehow. That will be done either by bringing additional cash to closing, adjusting the loan amount, or adjusting the loan to value ratio. If option 2 is elected and the buyer and seller have agreed that this is going to be a term of the agreement, then the buyer gets to decide how they're going to make up that difference. So the buyer doesn't necessarily have to bring more cash. The buyer has some options as to how they're going to make up the purchase price. The seller should not be agreeing that the buyer can proceed under option 2, but then refusing later to execute a change in terms addendum to change some of the terms in paragraph 8. There's nothing that specifically says seller must execute a change in terms addendum, but agreeing to this and then not agreeing to execute a change in terms addendum to allow the buyer to fully exercise their options shows bad faith and may potentially be a breach of contract claim. Speaking of paragraph 8, the mortgage contingency may still come into play if the buyers don't get the financing that they want. And some people see the mortgage contingency as an out for the buyer, and it is and it isn't. It is in that it's a contingency. So if the buyer doesn't get the financing, they're not going to be forced to complete the purchase of the property. However, it's not an out because who has the right to terminate under paragraph 8 of the agreement of sale? That is the seller. So unless and until that happens, the buyer is required to try and get approved for their mortgage that they said that they would be able to get. If the buyer has elected option 2 and told the seller that they understand what the purchase price is and they don't care what the appraised value is, then maybe the seller needs to think about a few things, like how likely is it that the property will appraise for the minimum appraised value in paragraph 1 or for the purchase price? What kind of financial strength do the buyers have? Maybe the sellers want to counteroffer with the waiving of the mortgage contingency altogether. Option 2 is not just option 2. It raises other questions, things that the seller has to think about, and also things that the buyer has to think about. Please don't explain this to your buyer clients as you can just terminate the agreement of sale if the property does not appraise, because that's not what the agreement of sale says, and it's not what this addendum says. Again, please read the terms of the addendum. We tried to make it as clear as possible, and also look at the guidelines for preparation and use that are available online. You have to be signed in to get them because they're a member benefit, but it is a step-by-step instruction manual, basically telling you how to complete the form, giving you examples, real life scenarios, some helpful tips. Hopefully something that will answer all the questions that you have about this form as you complete it and teach your clients about it. And one thing that I really didn't think I had to say, but apparently I do, an option has to be elected. So if you're using this form, we have option 1, which was basically the buyer's option to terminate or renegotiate. And we have option 2, which is buyer's option to say, I don't care what the appraised value is, I'm buying this property. One of those options has to be elected. If they're not, this form means absolutely nothing. So sellers, if you get this form as part of an offer, please review the addendum to make sure that the buyer has actually selected an option so you understand what might happen after the appraisal. Our last July 1 form is the seller's property disclosure statement. And this is what I thought would be the big to-do, but thank goodness for that appraisal contingency addendum. That was released, like I said, on July 1st. The red line version is available online. The change was not required by law. This was just a routine change that we do as a matter of course for forms in our library because it hadn't been looked at in a while, at least a major overhaul. And I collect complaints, questions, comments, suggestions. I collect every comment and present them to the Standard Forms Committee every year. And we had amassed a certain amount on the SPD and they said, it's time that we just do an overhaul on this. So there was no change that was required by law. So that means if you have transactions pending right now that have used the old form, it's fine. You can continue using the old form. You don't have to have your sellers fill out a brand new disclosure form. But moving forward, we would like you to use the new one. On the first page of the SPD is the exceptions. There's actually a lot of great information on this first page. And I know it's a lot of words, but I really encourage you to read it. The definition of material defect is in there. And what I think most importantly is the exceptions to the seller disclosure law. You'll see that there are 10 exemptions listed. Power of attorney is not an exception, and we will talk more about that later. Also new on the first page is the common law duty to disclose. So below the common law duty box is the executor administrator box that used to be on the last page of the agreement. We moved it to the front page. But we also put this note in here because it's very important. And there's a distinction between seller disclosure lawsuits for failure to disclose and fraud. But they often go hand in hand. Fraud is a common law tort claim, but chances are if your seller's being sued for failure to disclose, they're also going to be sued for fraud, because the way attorneys do things is they load everything into the complaint, throw it against the wall, see what sticks. So they're coming at you with everything. While the seller disclosure law says there are certain transactions and certain people who are exempt from completing the seller's property disclosure statement, there is still a common law duty to disclose. And that is just based on case law. It's based on, it's based on that claim for fraud. And it's part of the reason that we changed the agreement of sale last year or the year before, that said that the buyer has to provide the inspection reports to the seller. It's because of this fallacy that sellers believed that putting their head in the sand and refusing to learn anything about the property would protect them. Same thing with these exemptions. They felt that just because they're the executor, that they would be safe. And while that may be true for failure to disclose claims, like I said, failure to disclose claims come with something else. It's usually going to be, fraud, deception, unfair consumer trade practices, whatever. Those are subject to common law duties. So there is still a common law duty to disclose. You cannot over disclose. And I'm getting into the seller disclosure area, but I feel like I can't stress it enough. You cannot over disclose. So this box on the common law duty to disclose is very, very important. And if you have a client who thinks that they fall under one of the exemptions, please point out this box and have them read it. One of the big changes in the SPD is paragraph 16. This question, honestly, we went back and forth, round and round so many times. I don't remember how many drafts of the SPD we ended up with. I think it was in the teens. And a few of them were because of this paragraph. This question itself is required. So we couldn't just get rid of it. The seller disclosure law says that in a disclosure form, there has to be a question like this in here for anything, any item that will or may be included with the sale of the property. But the problem was with the old form, the options for answers were yes or no. And people were confusing the question with the actual intent of the form. Just remember what that intent is. The intent is to disclose material defects. It is not to tell the buyers what's included in the sale. So please read the question. We made it as obvious as we could. It's in caps, it's in bold, it's underlined. This section is intended to identify problems or repairs, and that's it. The fact that an item listed does not mean it is included in the agreement of sale. I don't know how else to say it to make it more clear. It's just going to take a lot of education. And I mean, even the members of our task force who worked on this form would sometimes get confused, and we'd have to stop and say, no, 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 you're thinking about it wrong. So when the question itself is, Are you aware of any problems or repairs needed to any of the following? If the answer is yes, that means the seller is aware of a problem. If the answer is no, it means that the seller is not aware of a problem. If the answer is NA, it means this property does not have that feature. So yes does not mean it's included. No does not mean it's not included. We are specifically asking about problems or repairs needed with these items. Ooh, don't know why that blank slide's in there. The other two new paragraphs are paragraph 17 and 18. Paragraph 17 is on pools, spas, and hot tubs. We know it's not going to be applicable for every property, but it can be a necessary disclosure, especially living in Pennsylvania where 8 months out of the year, the pool is closed. You're not going to be able to just open it up for inspection. And if chances are, if you pull back the cover, it may look terrible anyway. The intention is to just give a little bit of information when an inspection is not available. This again, and any question, honestly, on the seller disclosure form is not meant to be a substitute for inspections. It's just meant to provide the buyer with a little bit of information so they can decide what inspections they would like to conduct. Same thing for windows. The windows paragraph, when we started, it was very long, but when we looked at it more, we realized people probably don't know what all of these parts of the window are. So without getting too technical, but again, hopefully giving the buyers enough information to decide what inspections they would like to elect, we ask some basic questions about the windows, including skylights. So I will pause because that's the end of the forms portion. If there are any questions about the forms, I can answer those for you.
Yes, you can either type them in the chat or you can unmute yourself or raise your hand and unmute yourself and ask it verbally. So who has questions about these forms or the changes?
And there doesn't have to be questions.
Okay. How would the ACA be used with a price escalation? From Tyler Miller.
Very carefully. The problem is that with a price escalation addendum, you don't know the final purchase price when you make that offer. So your buyer is, when filling out paragraph 1, your buyer is still going to have to set a minimum appraised value or just take a gamble that whatever that final purchase price is, that they're comfortable with the with that being the minimum appraised value. And then again, your buyer just elects option 1 or option 2. Do they want the ability to terminate if that minimum appraised value isn't met? If so, then they select option 1. If they feel confident and comfortable that they'll be able to make up any difference if there is one, and they're not going to terminate the agreement, they're going to buy the property no matter what the purchase price, then they can elect option 2. But the real trick is figuring out the right number to put in paragraph 1.
Okay, and Tyler's follow-up question, and when buyer is willing to cover an appraisal shortage. So I guess that's a follow-up to his first question.
That sounds like it would be, if buyer's willing to cover what we call the appraisal gap, the difference between the purchase price and the appraised value, they can still choose option 1 or they can choose option 2. It's just a matter of what do they want to tell the seller? Do they want to tell the seller, like, we're still going to hold on to the option to terminate, or we still think maybe we want to renegotiate the price after the appraisal? Or do they want to tell the seller, we're good, we're going to buy the property and we will make up the difference? Because that's really the difference between option 1 and option 2. So it's what the buyer wants after the appraisal. What do they want their options to be?
Okay. Trish Mills asks, can you put the sheet up as she is talking about this? I can't, I don't know, Desiree, can you, I don't know if you have the forms actually right next to you, your PowerPoint, that you can actually revert to some of these forms as you're going through them.
What sheet?
The ACA.
I can go back to that slide. So this is paragraph 1. So again, if you're using a price escalation addendum, one of the problems is that you don't know what that final purchase price is. So if you leave this line blank, what is that, line 4? If you leave that blank, that means that the minimum appraised value will be the purchase price, which at this point, you don't know. You can set it for a different value if you'd like. It's going to take some thought and some math, but that can be done. You have to, this is what sets everything. So this is the minimum appraisal value that you're trying to meet. So you really need to make sure that you're choosing the right number. It's probably, especially if you're using a price escalation addendum, it's not enough to just leave it blank and rely on the purchase price. This is option 1. Again, if the buyer is trying to convey to the seller that no matter what the appraised value is, we're still going to hang on to that option to terminate, and we're still going to hang on to that option to renegotiate the purchase price, then they elect option 1. If the buyer is fine with whatever the purchase price is and whatever the minimum appraised value is, and they will make up the difference, then they elect option 2. The difference between these 2 paragraphs is what happens after the appraisal, what options the buyer has. Remember, I said when we started talking about this form, it's not so much about the fact that there is an appraisal gap, it's what the parties are going to do about it. There was no agreement because this was the old appraisal contingency addendum that says basically buyer gets to terminate or the parties renegotiate, but it left this confusion, these questions, people thinking the seller will just have to reduce the purchase price because it's supposed to meet the appraisal value. And you have the other half of people thinking that the buyer just has to bring more cash. It didn't answer just this part of the form, didn't really answer any of those questions, didn't clear anything up. So we changed it so the buyer has to indicate one way or the other, this is the direction they're going to go. They either want the option to terminate, or they might want the seller to reduce the price, or if they're electing option 2, they're saying, yeah, we're going to bring more cash.
I actually have a question about that. So does financing, the type of financing or loan you're using, you really have to, I'm assuming, know what your buyer is approved for in both of those cases then, because for as much as they might want a property, and they might be willing to say, yeah, we'll just, go above the appraisal, and, their financing might not allow for that, I'm assuming, in certain cases. So you really have to know what your buyer's situation is.
Yes, you do. And especially if there's a special loan product like FHA or VA financing, there are rules there that override what we have in our forms. So no matter what, I mean, there are certain things that a buyer can't agree to. So you have to know what you're doing, and that you have to know your buyer's financial picture and what they are actually capable of doing.
So do you recommend in that case to have like the buyer's agent should have like a consultation or like a follow-up or something with the lender to kind of get that understanding of what their limitations are?
I think that would be a good idea. I think it's also very important for the buyers to understand what their limitations are, because they need to, I mean, this is their deal. This is going to be their property, and it's their loan. It's their agreement. They need to understand what they're agreeing to. They need to understand realistically what they can borrow, what they can pay, how the loan product may affect that. We had people who just thought, well, they use this form thinking, well, I'll just pull money out of my retirement to make up the difference, and then found out that in order to do that, they would pay a hefty penalty. So it's a matter of asking those questions. If your client says, oh, well, we'll just bring more cash. Well, where are you getting that? Is it a gift? If it's a gift, are there any tax implications with the gift? Are they thinking they're going to pull it out of their retirement? Are they able to do that? Are they thinking they're going to just cash in some stocks or assets they have? Are they aware of the timeline to get that done? I think it's really important for the buyers to understand what is happening and what their limitations are. I mean, don't get me wrong, it's also very important for the agent to understand and to work with the lender. But I think it is incredibly important for the buyers and the sellers to understand, how this difference is going to be made up if they're electing option 2, especially because here, again, the buyer doesn't have the right to just terminate, which is another misconception, something that they need to understand. Not only are they waiving it by selecting option 2 of the appraisal contingency, but even if they've elected a mortgage contingency, they don't just have the option to terminate. That doesn't exist in paragraph 8. So they need to absolutely understand what they're getting into.
Okay. Any other questions that anyone wants to ask before Desiree moves on? Okay, if I see any more pop up in the chat,
Okay.
Desiree.
Let's get back to disclosure basics. Oh, this is one of my favorite topics. And I could probably, I want to kick myself because I sound like Hank when I say this, but I could talk for hours about seller disclosure. I won't, but this truly is one of my favorite topics. I think it's just because there's always something that people are learning, something new people are learning about seller disclosure, and it's kind of fun. So, like I said, we're just going to cover the basics. If you have more specific questions, feel free to ask me later. You can email me, you can call PAR, you can call the hotline. We'll be happy to talk to you about it. But just for your refresher or your knowledge, first, we're going to start with who has to disclose. That is a very good question to ask yourself at the very beginning. Does the real estate seller disclosure law apply to this transaction? And I'm going to suggest that you start with the presumption that it does, because it applies to the selling or transfer of any interest in real property that consists of between 1 and 4 residential dwelling units. So there's a misconception that, this deal's commercial. It's an apartment building, it's a commercial deal, it's an investment property, but it's 3 dwelling units. That means that the seller disclosure law applies to this transaction, and a disclosure form would have to be completed. It applies to all types of transfers of property. It includes for sale by owners. Like I said, it includes commercial. It includes exchanges, installment sales contracts, leases with an option to purchase. It includes grants of property. It's not just sales. And this is another reason why PAR does not have a lease to own contract, because these deals can be quite complicated. And they are subject to the seller disclosure law, which is something that people tend to forget. Same thing for FSBOs. Most people, lay people, are not aware that the disclosure law is a thing, and they're not aware of their obligation to disclose. But again, it applies to all sales. So even if they're selling without the assistance of an agent, they do have to complete a seller disclosure form. So who does not have to disclose? Remember that list of 10 exemptions that was on the first page of the SPD that's put there for your convenience. There are some exceptions. So transfer pursuant to a court order. If it's bankruptcy, if it's eminent domain, specific performance, something like that, then a disclosure form is not required. Transfer from one co-owner to another co-owner does not require a disclosure form. A transfer that's made pursuant to divorce, a mortgage default or foreclosure sale, transfers between family members, business entities, but only to shareholders when the company is liquidating. Property that is going to be demolished or converted to non-residential use, and unimproved real property are also excluded from the disclosure form requirement. You'll see here fiduciaries and estates and new construction are on the list, but there's an asterisk. So transfers in the course of the administration of a decedent's estate, guardianship, conservatorship, or trust, those are exempt from completing a seller disclosure form. However, this is where that case law comes in. Case law has held that even though they don't have to complete the form, they do have to disclose material defects. That is that common law duty to disclose. So if they don't want to complete the form, fine. They can sign that box on the first page and say, I'm not doing this. But if they have knowledge of a material defect, if my executor is my son who lived at the property since the time he was born until he graduated from college, and he comes to visit me once a week, and he's a very good son, comes to visit me once a week, and calls me all the time, and knows that I complain about the drafty windows or the leaky roof or the weird slope that's appearing in the backyard, then even though he's the executor and would otherwise fall under the exemption, he has knowledge of a material defect, and common law is going to get him if he doesn't disclose those to potential buyers. The other somewhat exemption is for new construction. So new construction is not a blanket exemption. There have to be 3 conditions met. So the buyer has to receive a written warranty of at least 1 year for the construction. The dwelling has to be inspected for compliance with the building code, and a certificate of occupancy or code compliance has to be issued. So if any one of those 3 things are not met, then the seller has to provide a seller disclosure statement. And I know that is easier said than done, because you're dealing with builders and construction companies who otherwise have no idea, but it's what the law says. It's on the first page of the disclosure form. It's in the law itself. Point it out to them and either have them provide a disclosure statement, or have them provide that written warranty, or get the building inspected. It's a good way to push them one way or the other. One thing that I forgot to mention about fiduciaries and estates is powers of attorney. Powers of attorney, people who hold a POA, they are a fiduciary, but they're not an estate. And they're not administering someone's estate. They're not acting as a trustee. They're not acting as a conservator just because they have a power of attorney. The power of attorney is a very different instrument from any of these other things that are covered by the seller disclosure law exemption. So we get quite a few questions on the hotline about, someone having a power of attorney and what they need to do, how they need to sign, what they fill out. They can essentially act as the attorney for the principal. So if they're given the authority to do so, they can enter into real estate transactions on that person's behalf. If they're doing that, then they're treated the same as if they were the seller. If there's no exemption for the seller, there's no exemption for the POA. A POA is not the same thing as a fiduciary, guardian, or estate. Common misconception. So, next question, what are we disclosing? We're talking about material defects. This is the definition of a material defect from section 7102 of the seller disclosure law. And that is a problem with a residential real property or any portion of it that would have a significant adverse impact on the value of the property, or that involves an unreasonable risk to people on the property. This is also on the first page of the SPD. The fact that an element, system, or subsystem is near, at, or beyond the end of its normal useful life, as in it's old, does not by itself mean that it's a material defect. I talked to someone on the hotline yesterday who was asking about a heating system, and the heating system did not work. That is something that could pose an unreasonable risk to people on the property, particularly, if we're in January, February, it's kind of essential for the property in Pennsylvania to have heat. On the other hand, if the heating system, if the furnace was just old, if the inspector revealed that the system is probably, 47 years old, and I swear I'm making up the number because I don't know what the normal useful life is for a furnace. But let's just say the inspector says it's old for a furnace. Just because it's old does not mean that it in and of itself is a material defect. It's just old. If it's broken, then that could be a material defect. Old, not a material defect. So how do we disclose? Where the law requires disclosure, the instructions are to complete all applicable items with the information that's known to the seller. So there is no duty to investigate or conduct inspections, and that specifically is stated in the seller disclosure law itself. But you can absolutely attach additional information if necessary. So I always tell people who call the hotline with questions, you cannot over disclose. yes, sellers may be angry and upset with you because of course they want to portray their property in the best light. But an ounce of prevention is worth a pound of cure. The problem with these disclosure lawsuits and what leads to these disclosure lawsuits is not the fact that you told prospective buyers at the outset, before they even made an offer, that there's something wrong with the furnace, or there's something wrong with the roof, or you had this problem with water leaking in the basement 3 years ago. The problem comes when the buyers purchase the property, they're moving in, the neighbor comes by with the plate of brownies and says, "Oh, I'm so glad the neighbor got that water problem fixed," or, "Oh, I'm so glad, someone decided to move in here and fix this up." Whatever it is, that's when people get angry. That's when they want to sue somebody, not when they find out before it's too late. So I promise you cannot over disclose. If you have a question about something that you think might be on the line, if it's enough of a problem for you to think of it as a question, then it's probably enough to disclose. So complete additional sheets if necessary. You can attach blank pages. You can attach, we have a seller disclosure addendum. It's form SDA. You can attach that to the seller disclosure form. But please try to convey to your clients that there absolutely is no over disclosure. If you've tried your hardest, I understand there are some people who are just simply unmoved. And what if the seller refuses to fill it out? So if you're the seller agent, there are a few things you can do. Section 284A of the Real Estate Commission regulations gives you one solution. And that would be to send a disclosure statement that is marked refused to the buyer. So you would simply write refused across the pages and provide that to the buyer, to the buyer's agent. The other solution, which is sometimes the less popular solution, is dumping the client. And seriously, you might want to consider dumping the client. You should probably document the file with a copy of your instructions to fill out the form, why you don't believe the property is exempted. Documentation is often a double-edged sword, because if you're wrong about the exemption, it's documented. But if you told the seller that they had to disclose the fact that the basement floods every time it rains, but then you never disclosed it to the buyer yourself, that is also documented. Keep in mind, the seller may claim that you never told them that they had to fill out the form. So be careful when you're documenting things, but if you are absolutely sure that you are right, and you are certain that there is no exemption, or you have a good faith belief that there is no exemption for this property, go ahead and document the file and say, this is what I said, this is why I said it. You're not going to be held to the same standard as an attorney. But as long as you are providing that advice, then that should be enough to help you, as long as you're acting in good faith, again, to avoid any liability for yourself. So again, you can mark the SPD with the word refused and provide that to the buyer, or you could just refuse to work with that seller client who does not want to comply with the disclosure law. Next is when the seller discloses. Section 7303 requires that the completed form be provided to the buyer before an agreement of sale is executed. However, the seller is under a continual basis to disclose up until the date of settlement. And I understand that complying with this requirement, especially when the market is, as crazy as it has been, can be a problem. Doesn't have to be a problem, but the form is long and sellers want to get their house on the market and you want to please your clients, and I get it. However, providing that disclosure form is supposed to be done before an agreement of sale is executed. It can be provided by personal delivery, first-class mail, certified mail, fax. Those are all the methods that are provided for in the seller disclosure law, and that can be given directly to the buyer, or it can be given to the buyer's agent, which delivery to one buyer or to the buyer's agent is considered effective delivery to all buyers. So if it's given to the buyer agent before the agreement of sale is signed, then it would be considered delivered to the buyers before the agreement of sale is signed. So keep that in mind. This, again, I live in the ideal world where everyone complies with the law and does what they're supposed to according to the timelines that they're supposed to do things. So of course I say this, with my, rose-colored glasses on, but I understand, of course you practice it and live in a different world. But this is when it is supposed to be done, before an agreement of sale is signed. Again, then at that point, buyers are not upset. They're not stuck in an agreement of sale with information they didn't know beforehand. They're not stuck with a property that has a defect they didn't know of beforehand. They're making their offer, entering into the transaction with all of the knowledge available. So it makes it, while they might be upset that maybe they didn't see something or didn't ask a follow-up question, if the seller has done their job and provided the information they're supposed to provide, it's very hard to attach liability to a seller, or for that matter, their agent. So I said that the seller is under continual obligation to disclose until settlement. Section 7307 of the disclosure law states that if any information is subsequently rendered inaccurate prior to final settlement, the seller has to notify the buyer of the inaccuracy. That means the seller has to update the seller disclosure form, even if there's an agreement of sale in place. The SPD has to be updated. It applies to the good and the bad, honestly. If let's say buyer one makes an offer, they do an inspection and they find something wrong, and so they terminate the agreement, but of course the seller now knows of a material defect. If they do an alteration or repair in order to fix that defect, then they're going to want to amend the seller disclosure statement in paragraph 8 to indicate that they've done these alterations and repairs. It's good practice to review the disclosure form at the time the offer is presented and again before closing, and that is both for buyers and sellers. So what does this mean for you as agents and brokers? Your responsibility comes from two locations. Generally, I'll refer to them both as the seller disclosure law, since that's where it's based, but I'll break it down for you here so you can see exactly what you are and are not required to do and where those requirements come from. So again, the first one comes from the seller disclosure law itself, which is actually part of the home transfers law. Section 7313, it requires sellers agents to advise the seller of their responsibilities to disclose and to provide the seller with a copy of the form. Note that this does not have to be PAR's form, but it can be any form that complies with the minimum requirements set forth by the Real Estate Commission. Something that I tell people who call the hotline when their sellers are kind of balking at filling out the disclosure form is maybe they'll agree to fill out the shorter one. And they'll say, what shorter one? The Real Estate Commission prepares a form that is the minimum form that's required. It's legally compliant. It's available on their website. It's not as pretty as ours. It's not as comprehensive as ours, But again, it is minimally and legally required, compliant. So I think it's maybe 4 pages as opposed to 13. So if your seller's kind of hesitant about filling out this long form, maybe they'll do the short one. It's available on the Real Estate Commission's website, either on that main page with a link on the right or under laws and regulations, but you should be able to find it on the Real Estate Commission's website. Section 7310 of the seller disclosure law says that you as agents are not liable for a violation of the law unless you have actual knowledge of a defect that was not disclosed or of a misrepresentation. So if you see a defect and you don't disclose it, or you know that your seller misrepresented the severity of a defect on the form, then you may be found liable along with the seller. Section 7311 of the seller disclosure law says that anyone who willfully or negligently violates the law or fails to perform any duty will be liable to the buyer. So while Section 7310 requires actual knowledge of a defect, Section 7311 allows the buyer to pursue an agent who acts negligently, which means basically you should have known better. So if you don't provide that disclosure form to your client and tell them that they have to provide it, or you don't advise them to consult with an attorney if they think they fall under one of the exemptions, or you don't review that common law duty box to disclose with them if they insist that they fall under one of the exemptions, you may be found to be acting negligently. The other thing that's important to note here is the damages. You're liable in the amount of actual damages, but the court can still impose punitive damages or other remedies. Like I said, lawsuits like this often involve claims for fraud, claims for breach of contract, and a failure to disclose does not invalidate an agreement of sale that's already in place. So when the buyer has already entered into that contract and they find out that there was something that the seller didn't disclose, they don't have the right to terminate. If they terminate, and that right's not given to them in the law or in the agreement of sale itself, they could forfeit their deposit. There are a lot of actual damages that could flow from that failure to disclose. But again, punitive damages, punitive means to punish. And the court is really going to punish people who are trying to defraud people, who are trying to break contracts. So the buyer being stuck with that property adds to the actual damages. And it also can just increase the punitive damages because the further along in the transaction the buyer got before they found out about this problem, the more likely it is that a court is going to impose some sort of punitive damages. The second source that lays out your responsibility as agents and brokers is the State Real Estate Commission rules and regulations. These were created under RELRA. So agents who represent sellers have to advise their clients of the duty to disclose material defects with the property. They have to provide a copy of the form to the seller, and they have to deliver the completed property disclosure statement to the buyer or the buyer's agent. So again, these are things that we've already talked about. You have to tell your sellers what the general law requires. Talk about the exemptions, but if they have questions, refer them to their attorney. Provide them with a seller disclosure form to complete, either our form or the Real Estate Commission's form, and provide that completed property disclosure statement to the buyer. If there is no exemption, you have to provide one, which is why in this same section, the Real Estate Commission allows you to provide one that is marked refused so that you can comply with this part of the obligation that they're imposing on you. Under this same section, licensees who represent buyers also have responsibilities under the seller disclosure law. They have to advise buyers that the seller has to complete a seller disclosure statement. And they have to make sure that the completed statement is delivered to the buyer. So what does this mean for you? Seller's agents, sit down with your client, explain what should be disclosed. Don't toss this form at them, or if you're using the new fancy Seller Shield or Glide systems, don't just email them a link and say, complete this. Go through the form with them. You can absolutely go through the form with them and let them know, what certain terms mean, the difference between a holding tank and a cesspool. Hopefully the homeowner knows that, but if they don't, you can absolutely answer some questions for them. If you're hands off with the whole thing, which is some agents' temptation is to just give it to them and then step back. But if you're hands off, there could be two results, and neither of them are really good. The seller could say, I asked and she didn't tell me I had to disclose it, which is almost as bad as she told me not to disclose it. The other option is you could be found liable because you knew from the listing process that there was a defect, but you didn't add it to the form if the seller left it off, or you didn't ask the seller to correct it. So in addition to discussing with the client what should be disclosed, you also need to review that form with them before it's presented to the buyer. Buyer's agents, likewise, sit down with your clients and review the information that's provided. Whatever's on that disclosure statement is obviously going to affect the terms of the offer. Maybe the price, the inspections your buyer wants, an appraisal contingency, whatever. Maybe your buyer won't want to submit an offer at all. Go over that form with them. And please remember to pay attention to paragraph 16 and what that actually means. Please, buyer's agents, don't tell your clients that because it's marked yes, it's included with the property. So what do the two of these things have in common? Obviously, sit down with your client. I understand you can't fill out the form for them, but you can offer them guidance on how to do it and how to interpret what information is provided from the seller. So please take the time to go over it. All agents disclose what you know. And this relates to the responsibilities that we discussed from section 7310 of the disclosure law. It doesn't just create liability for sellers agents, even though they are in a better place to know of actual material defects. It actually applies to buyer's agents as well. So some special circumstances, condo homeowners associations. When you're selling property that's part of a planned community, be sure to let your clients know that the disclosure form is not a substitute for the resale certificate and other information that's required under the Planned Communities Act. Also, remember to point out that disclosures only have to be made about that seller's particular unit and not any common areas. So if the elevator in the high-rise condo building is broken, that doesn't have to be disclosed. It's something that the buyer has an opportunity to look at and inspect. But if there's 4 elevators, maybe they didn't take that one. It doesn't mean that it's going to be on the disclosure. Doesn't mean it can't be, but it doesn't have to be. Second is lead-based paint. I don't know how this rumor started, but please help me stop it. The disclosure form is not a substitute for the lead-based paint hazard disclosure. That's form LPD. The lead-based paint hazard disclosure has very specific requirements as to what it looks like and the disclosures that have to be made. The SPD does not come close to meeting those requirements, so they are not a substitute. Last is the creepy, the spooky things. Material defects are physical defects. The Pennsylvania Supreme Court in Milliken versus Jacona, which was decided in 2014, considered a murder-suicide that took place in the property to be a psychological stigma and not the type of defect that the seller disclosure law was intended to cover. If you may or may not remember, this is the case. Mrs. Milliken was an out-of-state buyer who purchased a home only to find out later that a murder-suicide had occurred in it. She claimed that if she had known that before, she never would have bought the house. And the court said that it would be too difficult to determine what may disturb a future buyer to the extent that they would not want to live on the property when we're talking about things like ghosts and stigmatized property. That doesn't mean, though, that there aren't other disclosures that might have to be made. Like if there was an arson and the garage had to be rebuilt, that's something that would be disclosed. If the walls or flooring was replaced to get rid of blood or gunshot residue, if an insurance claim was filed for an injury or a wrongful death, those are questions that the seller disclosure form asks about, and those are questions that should be answered truthfully. The other question that we get a lot is about sex offenders and felons. I got one question about the seller himself was on the Megan's Law registry and whether that had to be disclosed on the seller disclosure form. And if the seller's not included with the property once it transfers ownership, then it's not something that would be a defect with the property. But nonetheless, Megan's Law offenders, felons, those are not material defects with the property. Those are things that are readily searchable and available for buyers to find out on their own. It's not a defect. There is no disclosure requirement needed. There's no notification responsibility on the part of the seller or the seller agent for those types of things. And I'll close with some friendly reminders. If you have legal questions, please feel free to call the legal hotline Monday through Friday, 9 a.m. to 3 p.m. We do return calls all day. Typically, you'll get, depending on when you call, you'll get 1 or 2 return calls the same day you call. Please, 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 I'm begging you, leave the spelling of your name, a phone number, and at least a topic about what you're calling about. So we have some idea of what we're getting into before we call you back. We have a fancy schmancy member management system that runs in the background and keeps track of all of the calls that we make. And one thing that we are always checking before we call back is membership status. So we're trying to confirm when you call and leave a message that you are in fact a member of PAR. If your spelling of your last name is complicated or you practice under a different name than what is on your license or your membership records and we can't find your contact record, it's just going to delay us calling you back, or you may not get a call back at all. So please remember those things. If someone said that their name was Jackie, but of course they don't practice under the name Jackie. They're not licensed under the name Jackie. It's Jacqueline, which was spelled strange. And it took me like 20 minutes to find out who this person is. So please be mindful of our time and just spell your name for us. Also, when you call or before you call, use your resources. PAR just listed, we try to update that and remove outdated information on a regular basis. So the articles and information you find there should be, if they're relevant, should be accurate. Also, I mentioned the guidelines for preparation and use. If you have a forms question, a lot of our forms have these guidelines, which again is that instruction manual that teaches you exactly how to prepare and fill out the form. Your broker manager, I understand they're not always available, but please contact them before you call the hotline and try to discuss the situation with them, particularly because a lot of times what we're going to say first is you need to talk about this with your broker or your manager. Another resource is this. Me and the other hotline attorneys, we are available to do local presentations on the forms, on the best of the hotline. I have another seller disclosure presentation that I do that gets even further in depth. MLS policy, membership issues, whatever. If you have questions about it, we'd be happy to do a presentation for you on it. And so with that, I'll stop talking for a second and give you a chance.
Thank you so much, Desiree. Does anybody have any other follow-up questions that they'd like to ask Desiree before we end today's session? Put them in the chat or unmute yourself. Okay. Looks like we are good on the questions. Wink says that she did send you 2 questions directly, Desiree.
Oh, okay.
Okay. But I see no other questions in the chat, so I'm going to, I don't know if you want to follow up with her directly, Desiree. I'm assuming she might have emailed you. But you can, I don't see them in my chat.
Okay. I don't see them in the chat. Oh, yes, I do. Yes, I do. Okay. Wink, I'll email you, okay?
All right. Well, that is all that we have for today. So I will let everyone go. Again, thank you so much, Desiree. We'll definitely look to have you guys back. We love having the legal department staff here to talk about all of these exciting issues. So thanks again and enjoy the rest of your day. Thanks everyone.